Is Mr. Morgan's pretrial conference order suitable for the court's adoption?
I think that it just needs to have my, I guess, I didn't include contentions in my questionnaire, but the issues as far as what needs to be determined by the court, and then the list of witnesses and exhibits from my questionnaire. Um, I think if those are incorporated in the order, um, and then I had included a proposed valuation date in my questionnaire. Um,
Of January 1, 2025.
yes, Your Honor, the date of separation.
Any objection to that valuation date, Mr. Morgan?
Yes, we use the date of filing February 5th, 25. Now, I don't know if it makes really any difference, but we have used the date of filing for all of our values. And we're talking about a month difference.
Mr.
And
Andrews, is that a difference that makes a difference?
I really haven't had a chance to look at it. So,
Yeah, and I'd have to go back and look to compare to see if that makes a huge difference or not. I know that there were some concerns at one point about money. See if I can find the dates. Uh, uh, if the court will bear with me, I can compare between my asset and debt spreadsheet and um, Mr. Morgan's and kind of see if that makes a huge difference on really it's the account balances and debt balances that it really affects. Um,
I mean, rather than to get bogged down on this today, Your Honor, I guess this could be an issue we address at trial to see if there is a difference. But this can take quite a while to go through all these balances to see if there's a difference based on 1 month.
Well, the court's supposed to establish a evaluation date at this stage, not at trial. So, Mr. Andrews, continue to take a look at what you need to. Obviously, you know Mr. Morgan's position.
I do.
The date of filing is the most appropriate date.
Well, and I could tell you, I think that maybe part of that, and I'd have to go back and look at the statements, but I noticed that there is a significant difference in a couple of the accounts of my clients, and I believe that's because she started to receive her inheritance between the date of the separation and the date of the filing, and that money was deposited in one of the accounts, and so we believe, and again, I'd have to go back and look at those to confirm, but that would be the only explanation for why, for example, a savings account balance that on the date of separation was $3,500, according to Mr. Zorn's spreadsheet, is $225,000 on the date of a later date. So I think that given the fact that the parties had essentially separated their finances when Ms. Zorn left on January 1, that she was no longer utilizing accounts where Mr. Zorn's money was going into those accounts, I believe. And Melanie, if I misspeak, please correct me. I think date of separation would be the best date for valuation simply because of the issue of inherited property going into accounts after the separation.
Wouldn't the later date more closely represent the actual financial position of the parties for this court to eventually analyze and determine?
I don't believe it would for purposes of valuation. If our position is that the court should not value the inheritance in determining an equitable division of assets and debts as part of that marital estate. And so based on our position that inherited, property that's inherited by one party, it would not be equitable for the court to divide that between the parties. We believe date of separation would be the better way of determining what the parties' relative financial position was, without including the inheritance.
Morgan, is there anything that you would add to your statement of position?
Otherwise, I think the date of filing is the best. You never know what's going to happen with parties before a date of filing. They could get back together, do this or do that. We kind of contest the contention that they separated everything. We didn't think they did. So we think the date of filing is the best. And I really don't think that inheritance versus the date of filing, I don't think that's determinative. The inheritance is a separate issue. We're going to look at it regardless of the date of filing, but the date of valuation. But we think the date of filing is the best date of valuation. And we've done everything. This is the first time we've heard it was yesterday. So I don't know what we'd do to change our numbers, but we
Well,
think the date of filing is best.
I mean, we're in the same boat, Your Honor. This is the first time we've heard that date of filing is what they're asking for instead of date of separation. In fact, I didn't even hear about it yesterday because it wasn't included in the proposed pretrial conference order. So today is the first date that I'm hearing that we're looking at date of filing instead of date of separation. So we'd have to change all of our stuff. I mean, we're both in the same boat in that respect.
The court believes that the later date is likely to provide the court with the most accurate picture of the true financial position of the parties for purposes of this case. The court will establish a valuation date at February 5, 2025, the date of filing of this action. All right. What I may be inclined to do, because we have a very short time frame between now and the start of our trial, which is currently set, I believe, for February 11, 9 o'clock, in person, courtroom B, Butler County Judicial Center. Will you be supplementing your questionnaire, Mr. Andrews? Or is that what you would present to the court regarding input toward a pretrial conference order?
Your Honor, the only thing that would need, I think, to be supplemented from my questionnaire is if the court is asking for a detailed summary of our contentions, I would need to supplement that because my questionnaire just essentially identified the issues to be decided by the court, as well as our proposed division of assets and debts to the spreadsheet and list of exhibits and witnesses.
All right. You're not objecting necessarily, except for the valuation date, which you've already dealt with anything that's in Mr. Morgan's proposed pretrial conference order, correct?
No, Your Honor.
Okay. Well, then, I'll just simply direct Mr. Andrews to supplement his questionnaire with his specific contentions. The court will consider them as part of the pretrial conference submissions made by the parties and will consider them at time of trial. And obviously, Mr. Morgan needs to be provided in advance, as much in advance as possible, Mr. Andrews, with any of this supplement. I want to make sure he has an opportunity to analyze what it is that you're presenting to the court. All right, trial begins 9 o'clock a.m. on February the 11th. Again, courtroom B, Butler County Judicial Center. Is there any other pretrial matter that you believe we need to address at this time, Mr. Morgan?
No, Your Honor.
Mr. Andrews, anything further from your perspective currently?
Your Honor, I wanted to confirm the deadline to deliver exhibit notebooks to the court and exchange with opposing counsel.
Since this is an in-person proceeding, you can submit your exhibit notebooks on day of trial as far as the court is concerned, but I do want opposing counsel to be aware of what's in your notebooks in advance. So what do you propose here, Mr. Andrews?
Your Honor, I have prepared my exhibit notebooks and was prepared to deliver them on Monday. However, I will now need to go back and revise my exhibit notebooks to reflect the new valuation date. And so I now am not, I don't know that I will be able to get that done and delivered on Monday. I can attempt to, and most of this, if not all, has been provided, I believe, through discovery. But I would ask if I could move the deadline to exchange with Mr. Morgan to Tuesday.
Okay. I don't have a calendar in front of me. The 11th next week is
Wednesday, Your Honor.
Wednesday. Can you get it to him by noon on Tuesday, Mr. Andrews?
Yes, Your Honor. Yeah, I would have to get it to him before noon because that's the only. I'd have to go first thing in the morning.
Okay.
The rest of my day's booked.
The court won't allow that, Mr. Andrews.
Thank you, Your Honor.
Okay, could I ask, Your Honor, are we talking about an actual hard copy delivered or an electronic copy? And I don't have a problem with electronic copy from Mr. Andrews if he agrees that I can do the same.
Well,
And
I was intending because I was just intending to hand deliver the hard copy because it would take me significantly more time to then scan those and give them to you electronically. So for me, since I was going to need to have a hard copy anyways for the trial, I was just going to hand deliver the hard copy.
That's fine, and we'll have ours available for you to pick up when you deliver.
That's perfect. I will plan on being there between 9 and 10 o'clock on Tuesday at your office.
Okay.
As long as you each have a hard copy for me.
Yes, Your Honor.
All right. And again, that can be delivered morning of trial. All right. Anything else, Mr. Andrews?
I don't believe so, Your Honor.
Mr. Morgan?
No, Your Honor, I think that's good.
Very well. Thank you all for your participation and again for your patience in getting started late this morning. If there's nothing further at this time, the Zorn matter will be in recess and this meeting.
Share your thoughts in the comments, and don't forget to subscribe for more courtroom breakdowns.